guys, it's Kathy. I hope you're doing well. We made it to Sunday night, and I got some stuff for you. It starts off right away with a bang. I mean, that the court case that it's involved in is a little slow at parts, but worth it. Payoff is worth it. We got a lady also later. She's suing for $600,000 for rugs. That I don't know how I feel about it. We got a judge that is so good after that. But oh my God, Bill is here. Guys, go watch American Courts. Go watch American Courts. I'm going to. All right, it starts off with a bang. Get ready, breathe. Here we go. Are you breathing? Okay.
Please,
y'all trying to hit me up for ass charges I didn't do. I ain't never been around that stupid ass white ass shit.
Next. And this is 513-41604
Yes, ma'am.
on arraignment. Good morning. And 602 on a motion to revoke.
I just wanted to state ahead of time.
Mr. Tart?
Yes, sir.
Let's hold off on the commentary.
No, actually, I want to say something because last time y'all stopped me multiple times for saying something, and I'm not going to have it happen this time. Not trying to be a dick or nothing, but my paperwork was stolen from me this time. And I want y'all to fair warning to know that.
Thank you. So, Mr. Tart, I'm gonna just go over the arraignment documents with you, which is the criminal complaint, and then also a motion to revoke that's been filed by the prosecutor's office. Okay, so if you can just bear with me, I'm gonna go over that. And then if there's information you want the court to know in addition to what you've already provided, then you'll have an opportunity to speak to conditions of release. So this morning, the charging document that you should have in front of you has one count of violation of a court order.
Yes, ma'am.
And that alleges on or about the 29th day of May, 2022, in the city of Bremerton, in the state of Washington, that you did with having knowledge of a Kitsap County District Court order previously ordering you that there was a protection order in place, a restraining order, and no contact order against Crystal and Mitchell, and that you did violate that restraining order.
No, they never called me around her. Incorrect.
Okay, I understand that you're denying that it happened, but this is what is alleged. Okay, so you don't have to agree with it, and I'm not asking you to agree with it. What I'm asking you to do is to just let me get through. Okay.
Sorry about
and
that.
This occurred. Thank you. And this is an occurrence that is contrary to the Bremerton Municipal Code as adopted by the RCW. This carries a maximum penalty of 364 days in jail and a maximum fine of $5,000. This allegation, the count one, the violation of a court order, has a
Violation of court order, count one. No. No way. Monica, thanks for the cheers this morning. I'm sorry I missed them. I was not in, everything was blowing up this morning. Guys, I don't know if you guys remember, but we're doing pizza and subs, hoagies, grinders, whatever you call them, wherever you are, for this stream. Mine's going to be here in a few minutes. So get your orders in.
Special allegation that this occurred against an intimate partner. And the court has reviewed the Bremerton Police an incident report, an investigative report that is set out here, and finds that there's probable cause that there was a crime committed. The motion to revoke is dated May 31st, 2022, and it is an amended motion to revoke, and it has 2 allegations in it. Non-criminal law behavior, and that has charges from the Kitsap District Court, which occurred in January of 2022, and then the current charges that I've just gone over with you in the criminal complaint, as well as failure to provide proof of evaluation and treatment, and that evaluation and or treatment is considered anger management. So those are the allegations that have been set out. Present on Zoom to assist with this process is Mr. Claridge. And the information as far as what your financial status, has anything changed since you were last appointed counsel?
No, nothing's changed. I'm still homeless and I still have no income.
Okay, thank you. So previously, in your underlying charge that is ending in the cause number 602, the LaCrosse Murphy firm represents you, and I would appoint them to represent you in these matters as well. And understanding that with the charge, the motion to revoke, that you're presumed to be and have not violated the conditions of your release or your JNS until the allegations are proved by a preponderance of the evidence, unless you admit to those allegations.
No,
So
I
Mr.
don't
Claridge is
admit to them.
okay, so Mr. Claridge is gonna assist with the remaining part of the arraignment at this time.
Okay.
Thank you, Your Honor. We'd ask to enter a denial and a not guilty plea for Mr. Tart at this time and set dates on the new matter for pretrial. Thank you.
Thank you.
Is there any
So
way I
the
can
record,
do this today?
the record will reflect denial to the allegations set out in the amended complaint dated 5/31/2022. And
Sodak replay crew! Kristen! Oh my gosh, it's so good to see you here! I read all your comments. Sodak replay crew all the time.
the record will reflect the not guilty plea to the criminal complaint that's been filed in the matter ending in 604. I'll hear from the city as to conditions of release.
Thank you, Your Honor. In the new case ending in 04, the city is requesting $2,500 bail. I've listened to Mr. Tart this morning, his comments to the court, but an officer, Jeffrey Schaefer, observed the two parties together at a local agency on May 29th as the allegation. So contrary to what he's saying, the city believes
So can I ask you one thing? No.
there is sufficient facts.
Bus, they gonna throw me on the bus. If they saw me in the same, no. If they saw me in the same area, that is both a business. We are both allowed to go with that business together. Maybe she.
Mr. Tart, please do not talk on the record at this time. Please,
Oh
please,
shit, y'all
please.
trying to hit me up for fuck ass charges I didn't fucking do. I ain't never been around that stupid ass bitch. Fucking white ass shit. No fucking charges, fuck ass motherfuckers. Charge me now. Motherfucker, they trying to fucking tell you the sounds around her. I never was around that bitch. I never was around that bitch. Don't shut me, you stupid ass cunt. Fucking shut me. Ass bitch. Cause I showed you the business at the same time you come up with this shit.
He's in crisis 3.
Let's see this.
I can get that stuff.
Defense is going to reserve bail arguments on this matter.
Can the court mind muting us for a minute, please?
Mm,
I'm asking for $5,000 bail. And
So, Ms. Harvey, let it go right now. I think she's muted. Okay. So the conditions of release that were set under Mr. Tart's arrest will remain until we can finish up the arraignment process with him. Again, I've appointed the LaCrosse Murphy firm to represent him. We'll put this matter on again. For Tuesday, June 14th at 8 a.m.
With all due respect, we might need to repeat that because we're trying to put our computer back together.
I will. I know you guys are trying to put things back together. So the next court date for Mr. Tart will be Tuesday, June 14th at 8 a.m. And the original bail set and bench warrants that were, the bench warrant that was issued, I believe, and my jabs went down, so.
Are you able to hear us?
We can hear you, yes. Let me know when you're ready, Joe.
Your Honor, we're ready.
Okay. So for Mr. Tart, the next hearing date will be Tuesday, June 14th at 8 a.m. And the bill and the 602 matter had previously been set at $1,000 that will remain. As to the 604 matter, the court will also set bail. Currently, it is no bail. That will remain until the next hearing.
And I have Mr. Narciso Hernandez as being the two that need to interpret.
Yeah, Mr. Chavo.
Okay. Mr. Chavo. Okay. So the remaining females I have a Miss Antonina Skipwith. Miss Skipwith, are you present?
Hear me out. We put Mr. Tard together with Miss Skipwith.
Miss Skipwith, if you could come up just a little closer so I can make sure you hear me. Miss Skipwith, is that you? Okay. Miss Skipwith, you're charged with one count of theft by shoplifting. Your bond is in the amount of $2,000, Miss Skipwith. You do have a special condition, of course, is to not violate any laws while on bond. You are also to stay away from the address where this alleged theft occurred. That's 2600 Maynard Jackson Boulevard here in Atlanta. Do you understand that, Ms. Skipwith? Yeah. Okay. Now, Ms. Skipwith, I was reviewing all of the information here. I see that you may not have gotten an opportunity to fill out everything, but let me ask you this, Ms. Skipwith. Do you have an attorney at this time?
No, I self-represent.
I'm sorry?
I represent myself while in the United States.
Okay. Well, Ms. Skipwith, for the time being, I am going to go ahead and speak to you about a court-appointed attorney. If you do wish to ultimately represent yourself, you can advise the court-appointed attorney at the appropriate time, as well as the judge who will be presiding over your case. Okay?
And when is the preliminary hearing for which an arraignment can be?
So for misdemeanors, ma'am, the preliminary hearings are scheduled for March 7th. But in the interim, you do have the opportunity to post bond. If you're unable to do so, then that will be your next court date.
Which would be when?
March 7th. That's what I was telling you. But let's talk about one thing at a time. So let me ask you this: are you currently working, Ms. Skipwith?
I've been arrested by representatives of the United States government twice. One for attempting to work,
Ms.
and the other
Skipworth,
for
Ms.
attempting to
Skipworth.
leave for work.
Ms.
So,
Skipworth,
that's-
answer the question that he's asking.
I'm sorry. Do I need interference to respond in the way that I choose?
Ms. Skipwith, I'm gonna ask you one more time. Are you currently working, ma'am?
I have been arrested twice by the United States government.
Thank
One
you, Ms.
for-
Skipwith. Ms. Skipwith, thank you. If you're not going to answer me, then I'm going to go ahead and appoint you an attorney. They will speak to you. Your next court date, Ms. Skipwith, your next court date is going to be March 7th, 2022. Excuse me, 2023 via Zoom. Do you understand that, Ms. Skipwith?
Then a month from.
I'm sorry, I didn't hear you there, ma'am.
I do not understand being unlawfully incarcerated and being refused amnesty a month from today. I do not understand that.
Okay, well, I've tried to explain that to you here this morning, ma'am. If you have been charged with an offense here in Clayton County, for which you do have to go before a judge in order to discuss that. But at this time, I've advised you, Ms. Skipwith, your bond is $2,000. You're to stay away from 2600 Maynard Jackson Boulevard. Your next court date is going to be March 7th at 8:30 a.m. It's going to be via Zoom. Do you understand at least what I've told you this morning, ma'am?
So until I post bond, March 7th is, if I post bond today, I leave today.
Yes, ma'am, you can leave today. Oh, I'm sorry, I apologize, ma'am. Go ahead.
If I post bond today, then I can leave until my court date.
So what would happen, as I was mentioning earlier, if you are able to post your bond, then the last known address that the sheriff's office has for you on file will receive any updated court dates that you have. And so you would need to then check your mail regularly, and they will give you whatever your new court date is going to be.
Is there a reason why I need to be in a co-ed facility? They won't let me wear my hijab. Can I be in a single-sex facility?
Unfortunately, ma'am, that's not within my purview. That's the sheriff's office. But do you understand the information I've given you?
I understand that.
Okay. All right, Ms. Skipwith. Well, I'm gonna move on to the next person, but thank you, ma'am, and good luck to you. Next is going to be Ms. Danielle Whitmore.
Basically, in short form, this case should be dismissed for want of prosecution. Ms. Ojeda has failed to prosecute the case with any diligence whatsoever, failed to meet the court's orders, failed to prosecute diligently, and we need to get the case over with. So we respectfully ask the court to dismiss the case for want of prosecution.
Okay, thank you. So let me just, what are the damages that are being claimed, sans interest and attorney's fees or whatever? What's the actual damages that they're claiming?
He claims that the rugs in the unair
Well,
conditioned.
the total, if I may, sir. Just
It's over $600,000.
Where are you, if I may ask? And besides, it looks like
I am in India, Your Honor.
Pardon me?
I am in India, Your Honor.
India?
Yes, sir.
Oh, wow, that's pretty exotic. Okay, so you know, I wouldn't characterize my. I don't remember going over when the attorney withdrew, but I wouldn't characterize my admonishment that I'll give you 60 days to get a new lawyer as an order to get a new lawyer. And the other thing is that people are entitled to represent themselves pro se, and that's how she's listed on the docket sheet. But Ms. Ojeda,
Yes, sir.
I saw another gentleman, Ojeda. Oh yeah, Ricardo. Is he involved in this as well?
Yes, they're my family. They're all trying to help me, sir.
He's an onlooker.
A supporter.
Okay, that's fine. He
And
can
he was with me when all the events occurred in El
Okay.
Paso.
All right. So some of the stuff that Mr. Walker was talking about.
Yes, Your Honor.
I'm
I
not-
would like to give my version.
Okay,
when
go ahead and
possible.
reply. You tell me whatever you want to tell me. Go ahead.
Okay. These were not just things there. There was 217 Oriental carpers hand-knotted. They were part of my husband's estate. When my husband passed, I had a lot of legal issues with insurance, with health insurance, with life insurance, and that's why I'm in India, sir, because he was a native of India. So I'm here also trying to defend my interest. That's why you see my brother, my nephew, they're also trying to help. These 217 rugs were stored there for close to a decade. $20,000 were spent in the storage. And there were some things going on, very ill administrated, and they had some people that they have put in prison. The manager has been in prison. I wouldn't be surprised if he committed any wrongdoing. I'm not alleging that there was an action. The fact that there was an action was told to me by their own manager, that they actioned my rugs for $218 in late fees, which I think is outrageous. After you take $20,000 from a customer, they never notify me. They had all my numbers. They had the address of my friend in Boston who was also supporting me to notify in case of any emergency, any amount pending, she would have taken care of it. She was never notified, nor was I notified. And perhaps my sister did help me to rent a unit because she was local, but I was the person paying. So naturally, by such a contract, I was the person in pain. These rugs are documented. There's an inventory of each and every one, and there were invoices produced to my lawyer, Mr. Villadant.
Go ahead.
Yes, these are twin brothers, Villadant. So he did a very good job, and he did fight their motion to dismiss. He fought it, and we prevailed. And I just think justice should be done, and we should continue.
Okay,
I
let
should
me
have
ask you,
the
Ojeda.
right to pursue my case.
Yes, ma'am.
Yes, sir.
Did,
Yes,
did,
Your Honor.
did your lawyer withdraw?
Yes, he did.
Okay, I don't need to know why. I don't need to know why.
Uh-huh.
I would have
Yes.
taken it up when I allowed him to do so. An issue of a statute of limitations does prohibit or stop any kind of litigation after that statute. In other words, you can't use the courts to collect however you were damaged. Okay?
Yes, but that's false, Your Honor.
But listen,
It was
Ms.
always
Ojeda,
observed.
Ms. Ojeda, you need to listen to me, okay? You need to
Yes,
listen
Your
to
Honor.
me because I'm trying to get this information without requiring you to come to El Paso to tell me in person.
Listen.
Yes, Your Honor.
All right? Is that you, Mr. Ojeda, giving her instructions?
Advice, yes.
I hear Judge Fleischer
All right,
saying,
well,
listen, listen.
Where are you?
I'm in Miami,
Okay.
Miami, Florida.
Okay. Single word suggestions to her helps. That's fine. But, you know, I'm the judge, and I'll give you permission to tell her, to direct her if it's going to help me get this out to her. Okay? There was no privity of contract. So you're doing this for your sister, or if your sister was on the contract, that doesn't necessarily keep you from being a party if you were actually injured as well. But privity means that the contractual obligation that they had was it your sister under whose name
Yes, Your Honor.
Okay. But he now told me that
Saying,
he
listen.
wants it dismissed because you're not pursuing the prosecution. How much time do you want to be able to come to El Paso and to find a lawyer? How many months?
Okay, my brother and my nephew are already trying. I don't know how long that will take. Maybe that will be not in such a long time. If not, I will try to be there in the fall, Your Honor.
Tonight.
Somebody said something.
6 to 9 months.
6 to 8 months? Okay.
9.
I'm going to give you Ms. Ojeda.
Yes,
And
Your Honor.
Mr. Walker, I'll take argument if you object to that. I'm going to give you to the end of the year to have a lawyer and to make an appearance.
Yes, Your Honor.
Okay?
I would like to say a couple things on the record, if I may.
Okay, Rachel, let's get back on. Wait.
Whenever you're ready. Whenever you're ready.
Yeah. Rachel, let's get back on the record.
Thank you, Your Honor. I appreciate it. Now, I represent Hawkins Self-Storage, which is an El Paso County taxpaying entity, and is entitled to rely upon the rules of procedure and the law that applicable to this case. And that law requires parties to prosecute their case with diligence. The same is true for anybody, anywhere. What we have here is a case of what is a case that in substance is fraught with significant legal problems and has been abandoned not only by the party failing to prosecute it, but no lawyer will now take the case. Hawkins Self-Storage is entitled to have this case resolved within the rules that the Texas Supreme Court has prescribed. They're paying taxes in the county. They want to have the case heard, dismissed, moved in whatever way is appropriate. Now, the basis for the motion to dismiss for warrant of prosecution I filed on February the 14th are stated at length in that motion, which I adopt by reference. We discussed that off the record prior to the court going on the record, and I adopt by reference those same arguments. We believe strongly that the case should now be dismissed, but in the interest of justice, I understand the court's position to try to allow Ms. Ojeda to have a little additional time. The court's initial thought of an additional 90 days from today is extremely generous. And I think that under any circumstances, that would not be seen as any abuse of discretion to grant 90 days. To waiting until the end of the year to allow Ms. Ojeda to try to find counsel who are available by telephone, by Zoom, by all sorts of means via the internet is far, far too long. If the court is going to consider not granting our motion at this time, I highly recommend that the court stick with the original thought process of granting 90 days in which to find counsel, or the case should be dismissed for warrant of prosecution.
Okay. Is that it?
Yes, thank you, Your Honor.
Yes, sir. So fair enough. You know the relief that you have if you think that I'm abusing my discretion. And I did take into account all the circumstances, and I find both sides in a very difficult position. And that was the basis of my decision, and I'm not going to change it. But I appreciate you bringing that up. We got a record, and your interests are also accordingly preserved. Okay? The other thing is, Robert, set this case in January. And Mr. Walker, if a lawyer enters into the proceeding before that time, you can set a hearing because the whole basis of this is for me to allow Ms. Ojeda to have a lawyer, and because she's in India and under that kind of hardship with respect to, I don't know what she's working on, perhaps on the estate, I've granted her that sort of leave, but once she has a lawyer present, you may accelerate the case by getting a quicker setting. You're not prohibited from doing that.
Downtown, can you turn on the camera and unmute yourself, please?
Yes, Judge.
We've been waiting for close to 40 minutes. What happened?
Thanks for the cheers.
I just got told by the sergeants to help out, so I'm trying to get as fast as I can to everybody.
Who do you have on that floor?
Let me get my list. Give me a second.
What floor are you on?
10th floor.
On the 10th floor, Your Honor, it's Betsabe Prieto and Ashley Garcia.
Okay, do you have them already?
No, I.
So this clip that I'm showing right now is a little different than what I normally show. Normally, I love the judges, and I'm always on the judge's side. But this judge is extremely angry at the jail for not having the people ready when he's ready for them. Well, the jail's busy because, you know, it's jail. This poor guy only just got there. He drove the whole way to the jail to try to help out right now because they're very busy.
Just got here. A second, Judge.
Every second that is going by right now, the judge is getting more angry. And just so you know, the annex is where the judge is at right now. It is not the jail. That information is a tool you'll use later.
Judge, this is Garcia Ashley.
Ashley Garcia?
Yes, sir.
Good morning, Ms. Garcia.
Morning.
Ms. Garcia, you are here on a number of cases, most of which I do not have the authority to hear because they're what we call SB9. The only one that I can hear is a possession of a dangerous drug, which is a Class A misdemeanor. Even if I release you on a pure bond on that case, you're not going to get out of jail until you post the other bonds, okay, on the felony cases. And if I release you on a pure bond on that misdemeanor.
Holy shit. Really? Is someone messing with me right now? Are you guys messing with me? Linus! Linus! Oh my God, it's Victoria. Hi, Victoria, love. How's work? We all want to know. I hope Michael treated you well for Christmas. I hope he put all the toys together. Victoria, we miss you and love you a lot.
And you don't get out of jail because you can't afford the bonds, you're going to stop receiving credit for any time that you spent in jail on that misdemeanor. Is that what you want, or would you rather waive it today?
Waive it today.
Okay. All right. Do you concur, Ms. Lozano?
Yes, Your Honor.
All right. I will mark you down as waived. Thank you, ma'am. Have a good day.
Thank you.
No, no, Josh. No, you can say it. Unless YouTube stopped you. But we don't hide the fact that that is Big Dick Vic. Victoria, would Judge Fleischer yell at the guards because they had to wait this long?
Judge, this is Prieto.
Good morning, Ms. Prieto. Ms. Prieto, you're here on a possession of marijuana. You're gonna be released today on your own recognizance. Do you understand that?
Sorry?
Can you hear me?
A little bit.
Can you get closer to the camera?
Okay, here.
All right, you're being accused of possessing marijuana less than 2 ounces. You're gonna be released today on your own recognizance. You understand that?
Yes, sir.
All right, thank you very much. Have a good day.
Thank you, likewise. Happy New Year. Bye-bye.
Happy New Year. Officer, have
Yes,
you
sir.
ever done these bond hearings before?
Yes, I have. I'm just trying to get them as fast as I can to help you guys out.
Okay, well, you're gonna need to move faster, okay?
Okay.
Because it's already 10:42. We've been waiting for 40 minutes, and I need you to move a little bit faster. Mr. Hill?
Oh, I know assaulting a judge is a crime, so I can't. But this judge has me pretty close right now. How dare you, sir? What do you think they're doing over there? Playing Candy Crush? You think they're in the jail just, eating pizza and hoagies? Judge, do better.
Hills, what is your client's name?
William McCoy.
Can you go to where Mr. William McCoy is?
Yes.
All right, we'll be in recess till then.
Judge, I have Etienne Noreen here from the 10th floor.
You have who?
Etienne Noreen from the 10th floor.
I asked you to get William McCoy.
Okay.
He
Give
can't
me the name
get
of the
William.
person that you have there, please. Etienne Noreen is an SB9 case. I do not need to see her.
Okay.
We're gonna take a 10-minute break. I need to resolve this problem.
Officer, we need to be on the 11th floor, 11th floor.
Judge McCoy is at the annex.
Officer, it's showing that he is in cell block 1122. Is that the annex?
1122. Yes, that's the annex. McCoy is at the annex. I'm gonna make my way to the 11th floor and I'm gonna get Sierra Vanessa ready. And then I'm gonna make my way down through all the floors. Okay. All right, well, I'm going to the 11th floor.
The person they want is at the annex, which is where the judge is at, not in the jail. They had no chance of doing what the judge
Sierra
wanted.
Vanessa here with me from the 11th floor. Yeah.
You're gonna give Victoria some snow? What, does the governor want to go to Mexico?
All right, who do you have there?
Sierra Vanessa from the 11th floor. And Judge McCoy is at the annex. He's not at downtown.
All right, Mr. Hills, I'm gonna have to reset your case to tomorrow. Okay?
Tomorrow?
Tomorrow at 1:30 in the afternoon.
Okay.
1/4/2025 at 1:30 p.m. Notify
Okay,
David Hillis. All right, sir. Thank you.
Your Honor.
Apologize for the confusion.
yeah, he was there yesterday. I saw him yesterday. I guess I took him last night.
You know what? I'm gonna reset him to tomorrow, okay? Tomorrow's Sunday, right?
Yes, sir.
It'll be tomorrow at 10 o'clock in the morning, okay?
I gotta be at church, Your Honor.
Okay, would you prefer on Monday?
Yeah, if you can do that.
Okay, Monday's fine. Monday, the 4th at 1:30 PM. All right, sir. Thank you.
Okay. I've got, can I be a little bit late? I have a deposition at 1 on Monday, so.
You can be a little bit late, okay? I will put it here, we'll be late.
Okay.
All right, thank you, Mr. Hillis.
Thank you, Judge.
Have a good weekend.
Yeah.
Okay, good morning, ma'am. Can you tell me your name again?
Vanessa Sierra?
Vanessa Fierro?
Yes.
I don't have a Vanessa Fierro, Judge. I have a Vanessa Sierra.
Sierra with an A.
Sierra.
Okay.
Okay, thank you. I'm a little deaf today.
That would make two of us, Judge.
And a little upset. I think it's much more the anger that is making me lose my hearing. All right, good morning, Ms. Sierra.
So, in case you missed it, he's still saying how angry he is about the jail in the cases when he's talking to people. This judge is on my last nerve right now.
Ms. Sierra is being accused of driving while intoxicated. Risk assessment level is a 1. Is this an accident, Ms. Vallejo?
No, it's not, Your Honor. It's driving on the opposite way of the street.
Okay, what was her BAC?
Point
It was
zero.
a blood draw. Oh.
It's a blood.
No, the specimen provided 0.08 and a PBT, Your Honor.
And a what?
Portable breath test
Okay.
that the troopers have on their units. And she also, Your Honor, she has no prior history, but she also admitted to smoking marijuana. And at the time of the traffic stop, the car smelled like marijuana, and so did she.
All right, ma'am, you're going to be released today on a personal recognizance bond under DWI conditions. You are ordered not to use drugs or alcohol, submit to random urinalysis, stay in contact with the PR bond office, and do not commit any further crimes. Do you understand that?
Yes, I do.
All right. Thank you. Have a good day, ma'am.
Thank you.
Good morning, sir. What is your name?
Good morning, sir. Sergio Acosta?
Sergio Acosta.
Correct.
All right, Mr. Acosta, you're being accused of evading arrest or detention with a motor vehicle and resisting arrest. Your risk assessment level is a 2. He's got 2 DUIs that were dismissed from 2020. It could be just 1, and he says he's got $500 for bond. Ms. Lozano?
Thank you, Your Honor. Mr. Acosta is 23 years old. He is a U.S. citizen. If released, he will be residing at 100 Sahudo Drive in El Paso, Texas, 79928. He has been at that location for 1 year and has been in the El Paso area for 23 years. Mr. Acosta is married, does have 2 children that depend on him, and his wife is currently pregnant. He is employed, self-employed landscaping, has family and friends in El Paso, does not have a physical passport, and has a pregnant girlfriend, Your Honor. He stated to me that he has $200 cash available for bond. So we would be asking for a significant bond reduction or a PR bond in this case. Thank
Okay.
you.
Thank you. Ms. Vallejo?
Yes, Your Honor. On 1/1/26, the deputy observed a Toyota Tacoma with an expired registration. The deputy activated his emergency lights and attempted to conduct a traffic stop. However, the defendant refused to stop. The defendant had an opportunity to stop but failed to stop. The vehicle then drove onto a front yard at the residence of 108 Sahuaro and came to a stop. The defendant immediately exited. The defendant told the deputy that he was already home and was being uncooperative with the deputy. He told the deputy that he had been at Andales and had drank 3 beers at the restaurant. Deputy smelled the odor of alcohol and observed red glass eyes, and his speech was slurred. The deputy then placed the defendant under arrest for evading with a motor vehicle, and the defendant started resisting, Your Honor. And then, as far as the criminal history, the first CWI judge, charges were dismissed, but because the defendant completed deferred probation. And the second 2020 DWI, that one, the charges were dropped.
Jen, sending Victoria your credit card information, telling people to send Victoria their credit card information is very dangerous to do online. Very dangerous, guys. Send it to me, and then it's not dangerous. Do not send it to Victoria. Send it all to me. Don't forget, I need the 3-digit code on the back. You better give me your mother's maiden name just in case, to be safe. Safety first. We're talking about safety here. Internet safety.
Was he arrested for DUI?
No, he wasn't. It's not showing.
Okay. All right. I see here that Mr. Acosta has on several occasions received a PR bond. And he was violated once, twice, 3, 4 times. Okay, so I don't think he's a good candidate for PR bonds. So, Mr. Acosta, on the evading arrest, I'm going to reduce your bond to 2,500 cash corporate surety. On the resisting arrest, I'm going to deny it based on your prior criminal history.
All three,
Do you
Linus.
understand that?
Yes, sir.
your
I just want to
bonds are
explain, and I was never trying to run away, sir. I was just pulling over because of
Mr.
the-
Acosta, remember what we talked about? Everything that you say is being recorded right now.
Right.
And there is a court reporter present and the state is present. So I'm going to
Right.
advise you that you do not speak regarding the facts of your case.
Okay.
Understood, Mr. Acosta?
Yes, sir.
All right. Thank you very much and have a good day.
And Your Honor, that DWI was declined by the office.
Okay, I see. All right. Thank you, sir.
Thank you, sir.
Is being accused of criminal mischief. Ms. Vallejo, what are the facts?
Your Honor, this is one that we're agreeing PR bond. You still want to?
Correct. What happened?
The defendant intentionally damaged a cabinet door and put a hole in the wall in the home of his parents with a damage of $200. We just ask that he does not go back to 14621 Portage.
Okay, he committed a criminal mischief on 11/17/2025. I released him on a pure bond. May now go then with 200 yards of a residence. Is it the same?
I
Is
would
it the
have
same
to,
victim?
it's going to take me a couple of minutes. Just
That's okay. Let's see.
Judge, so we did speak a little bit about his previous case. He did let me know that yes, he was arrested for a previous criminal mischief. He was on PR bond and he was reporting.
Okay, what is the on the new criminal mischief, Ms. Vallejo, what is the location of the damage?
14621 Portage, Portage.
Ms. Lopez, is he still on PR bond for the criminal mischief that occurred in November?
Yes, Judge, and that's under administrative conditions.
He's under administrative conditions. He was supposed to have no offensive contact with his father. He was not to go within 200 yards of that address. Okay, so no, he's not gonna get a PR bond today. All right, go ahead, Ms. Lozano.
Thank you, Judge. Mr. Quinones is 19 years old. He is a U.S. citizen. He has been at the Port AJ address for 19 years, has been a lifelong citizen of El Paso. He is single, Your Honor, does have a job at Rodriguez Inc. Construction, has been there for a year. Mr. Quinones does suffer from a mood disorder. As I stated, Your Honor, he was on PR bond and had reported. He has family and friends in El Paso. No passport, does have a job. We would be asking for another PR bond as he does have $0 cash available for bond. He did let me know that the way he reported is that he left a message because the PR office has been closed for 2 weeks.
Okay. Ms. Lopez, were there any issues with him reporting?
No, Judge, he did orientation and he was reporting.
Okay, the only problem is he keeps damaging his father's house. Okay? One of the rights that you have, Mr. Quinones, is the right not to say anything because anything that you say here today could be used against you in court, especially since we have a court reporter taking down everything that we're saying. Knowing that, do you still want to make a statement?
I kind of do, sir, actually.
Mr. Quinones, I have to advise you against that.
It's because I did have permission to stay in my mom's house. Like she gave me the permission to stay there even though I had the restriction order.
Okay, well, here's the bottom line. Your mom does not have the authority to modify my order.
Yeah, you're right there, sir. My bad. I'm sorry about that, sir.
All right, Mr. Quinones, I'm going to deny any bond reduction at this time based on the nature and circumstances.
Judge, his mommy said so. You can't overrule his mommy. How dare you?
Of the alleged offense, your prior criminal history involving criminal behavior against your dad and for their future safety. Ms. Lopez, do not file a notice of violation on the other cases. Now, if your father or your mom choose to bond you out, they're more than welcome to do that. All right, sir? But you cannot go back to that house because you're still under my bond order on the other criminal mischief.
Okay, sir. So if they wanted to bond me out, what would be the...
Your bond right now is set at $1,500. Okay?
Okay, sir.
All right, thank you.
Thank you, sir.
Who's next?
Sir, I'm on my way to the 6th floor.
All right, thank you, officer.
And 750 for the obstruction.
Thank you.
21.
Thank you. DeMarcus Marcel Rucker is accused of criminal trespass and willful obstruction. Mr. Rucker, you've been advised of your rights and your attorney is Ms. Tucker, and your accusation is 26 CR 047C. Any priors?
Rucker, 17. He got an open reckless conduct. 25 CR 007 153C. Open battery out of Clarkston. 2016 ag assault robbery conviction. 2015 failure to appear. 2014 possession of a firearm by convicted felon and some old FTAs.
Thank you. Ms. Spear?
Yes, Your Honor, there's a $1,000 surety per charge already set. We would ask that that remain. No further contact with the victim, Jeffrey Milligan, who is on Zoom and I do believe wishes to address the court. Stay away from 1334 Jonesboro Road. No drugs, alcohol, or weapons while on bond. And if we could sound for Mr. Milligan. Thank you.
Jeffrey Milligan, if you want to address the court, please unmute and start your video.
Yes, Your Honor.
Raise your right hand.
Mr. Rucker. Oh, I'm sorry.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. What would you like to tell us?
Mr. Rucker was a resident of my house and it's a shared living house. He ran everybody out the house, tried to take over the whole downstairs, which was 6 rooms and 3 bathrooms, and said that he owned the house. When I came there, this was in October, when I came in there to actually change the locks and give him a key, he actually shot a gun at my foot and he ended up getting locked up. I believe he must have just got out within the last 2 days and he came over to the house, broke into the house. He ransacked some resident's room, stole some money and jewelry.
Mr.
and-
Milligan,
Go ahead.
please, Mr. Milligan, when did all this occur?
Pardon me?
When did all this occur?
This occurred this occurred yesterday about him breaking into the house and ransacking and stealing the person's jewelry and money. But the shooting occurred October like the 29th. And he has been locked up ever since then until I guess yesterday. And then he came back to the house, broke into the house.
Okay. Thank you. I got the gist. Thank you so much.
Okay.
All right. Ms. Tucker?
I will be filing a restraining order, Your Honor.
All right. Monday morning, don't forget.
Yes.
Ms. Tucker?
Yes, Your Honor. Mr. Rucker is 33 years of age. He was able to provide me with a different mailing address. He is an Atlanta native. He's currently not employed, but he does have one minor child that he helps support. We are asking for a signature bond in this matter for Mr. Rucker because as Mr. Milligan just explained to the court, Mr. Rucker was a resident at this address. He has been consistently incarcerated since October 28th of 2025. He was just released yesterday, January 2nd at 4 a.m. He returned to what he believed to still be his residence. He has not been served with an eviction notice. So he had no prior notice that he was not allowed to return to his residence. So of course, after leaving jail, he went back to what he assumed was home. Due to the facts in this matter, we are requesting a signature bond if the court finds it appropriate.
All right. Mr. Rucker was seen by me on November 7th, 2025 at his first appearance. I'm sure I'm a very forgettable person, so I wouldn't be surprised if he has already forgotten me. And he received a $2,500 surety bond, and he was told by me in open court, just like this, back on November 7th, that he is required to stay away from 1334 Jonesboro Road. He's not allowed back to the property, and he was to have no further contact with Timothy Daniels and Jeffrey Milligan. And that was expressly written in the bond order in that case. Now, his bond in that case, 25 CR 007153C, the reason he got released wasn't because the case was dismissed. It wasn't because the bond conditions were modified. It was because the bond amount was reduced to $1,500 instead of $2,500, enabling him to post bond. But the bond conditions were still the same. No further contact and stay away. Those conditions were never changed. I'm looking at the bond order issued by Judge Dixon, and I'm looking at the order issued by me. No changes. So this incident from January 2nd is a violation of the bond order from November 7th, 2025. Mr. Rucker, I know you are eager to correct me, but I'd like to remind you that anything you say right now can and will be used against you in the treatment of your case. On the criminal trespass, that's going to be a $1,500 cash bond. On the willful obstruction is going to be a $500 cash bond. And we're going to reset both cases to January 15th of 2026. Again, as I explained to you back on November 7th, Mr. Rucker, you are to stay 200 yards away from 1334 Jonesboro Road in South Fulton. You are to have no contact with Jeffrey Milligan. You are to stay 200 yards away from both the location and the individuals in that property. You're not allowed to communicate with them in any way, form, or manner. The bond order requires you to also have no firearms based on the victim's allocution. I don't know if there's evidence that you possessed firearms on January 2nd. If you did, that's another violation of the bond order. I don't know. I'm not making a ruling on that aspect. But your total bond for this case is a $2,000 cash bond.
Your Honor, My apologies. If he were to make bond on this,
Let me finish. Let me finish. If he does post bond, he'd be required to be equipped with an ankle monitor. The ankle monitor will be for a period of 6 months, and he will pay for the monitoring expenses himself. And this will assure not only the court, but also the victims that Mr. Rucker is complying with the no contact and the stay away requirements. Okay. Yes, Ms. Tucker.
Your Honor, I was just going to request a one-time police escort to pick up any remaining property.
Absolutely not.
Retrial, so.
Absolutely not.
Your Honor, may I speak 1 second?
Mr. Milligan, just 1 second, please. Hold, please. All right.
Yes, Your Honor. Thank you.
All right. Mr. Rucker, I just need a yes or a no. Do you understand the bond conditions at the present time?
Not quite. May I please make one statement?
I can give you a call, Mr. Rucker, if you don't understand the judge's explanation.
Okay, well, what I'm saying is, my appearance for November, it was waived because I was having diabetes problems in here. So they ended up waiving my appearance. I never showed up in court. I didn't have no knowledge about, I promise you, I didn't have no knowledge about not returning to their residence. I promise you, I didn't have appearance.
Did you get a copy of your bond order before you were released?
No, ma'am, not at all.
Then that's your problem, not mine.
I didn't know. See, my plan was
that is not my problem. That is yours. You are required to obtain a copy of your bond order. If you don't understand it, you should ask your attorney.
Yes, ma'am. But far as the warning, far as November, I never sat right here and faced nobody. That's my word. If you can go back and you can check, I waived my appearance.
Okay, if that's the case, then that's still my bond order. If you want here to receive the allocution of the bond conditions, your attorney definitely was. So make sure before you post bond, you get an equipped with an ankle monitor and get a copy of your bond order in this new case and get a copy of your bond order, actually your 2 bond orders from your older case.
Yes, ma'am.
And if you violate any of those conditions, your next case will be no bond. All right. Mr. Milligan, very briefly, what do you want to tell me?
Mr. Rucker was legally evicted the day he got
Mr.
locked
Milligan,
up.
no, I'm not interested in that part. Anything else about the bond?
Oh, no. He
All
just
right.
doesn't have anything over there. I don't know why they got to come over. That's all. Thank you,
Well,
Your Honor.
He's not coming. He's not supposed to come. If he shows up, please let the police know. Thank you. Next case. Your attorney is going to be Miss Anthony. Any priors?
59. You got an open case out of state court, but it's probation. It's for driving and obstruction. And the simple battery probation as of October 25 CR 006 656F. 2025 failure to appear, 2016 battery DV conviction.
I'm sorry, what year was the FTA?
Last year, 2025.
Mr. Rhodes?
Yes, Your Honor. As it relates to Mr. Davis, the cycles out of both California and the state of Georgia, Your Honor. So he's a multi-state offender.
This judge drops a line on him that shuts him right up soon. It's epic.
At this time, we're asking for 20. In light of the history, we're asking for a $2,500 good bond, and that he has no further contact with the victim in this case, Ms. Shantae Ford, and that he stay away from 574 Cedar Avenue, Northwest Atlanta, Georgia. We're also asking that he undergoes 24 weeks of family violence intervention program, 24-week FFIP, and it looks like I might have missed in his criminal history. I will check to see if there is a previous battery family violence case, Your Honor. The state may transfer this to Superior conviction, that is. We would transfer this to Superior Court. I thought I heard Mr. Howard say that. So I'll double check that. but that'll be something that we'll address later. Thank you, Judge.
Ms. Anthony?
Yes, Your Honor. Mr. Davis is a Georgia resident. He did complete high school and has extensive work history in welding. He is employed with over 10 years experience. He did state that he doesn't have any children with the alleged victim, and there's no means of contact, as well as he does have somewhere else to reside. So we just ask that he be given a signature bond or the lowest bond that the court's willing to impose for him today.
Bond is set at 2,000 is a surety bond to have no further contact with Shante Ford. Stay away from 574 Cedar Avenue in Northwest Atlanta. He is not allowed a one-time visit, not allowed a one-time visit to the location. This is virtually word for word the same bond with the exception of the amount from 25 CR 006656F, which was the case in which he took a plea last year. Same victim, same location. Next court date is January 15th. Thank you.
Your Honor, may I inquire, was that a battery family violence plea?
That was a simple battery family.
Oh, thank you, Judge.
Can I say something, Your Honor?
You have the right to remain silent. Anything you say in open court, your statements can and will be used against you.
I don't reside at this place and we're not together, so I don't see how I could be in family violence with this.
Mr. Rhodes?
Yes, Your Honor. Give me 1 second here. I will pull up that warrant.
The judge will
Yes, Your
shut
Honor.
him up, don't worry.
The facts of this case is between November 13th, 2025 at around 5:40 a.m., Atlanta Police Department were dispatched to the location of 574 Cedar Avenue Northwest in Atlanta, Georgia. And essentially, on November 13th, Officer Lawson responded to that address where a child actually called, and Mr. Julian Freeman called, who stated that his mother's boyfriend, who was later identified as Mr. Ashanti Davis, were involved in a verbal and physical altercation with his mother. They then spoke with the victim, Ms. Shante Ford, who stated that she and her boyfriend, Mr. Davis, were involved in a verbal altercation over her giving him money. Ms. Ford stated that they were hanging out the night before, possibly around 12:01 in the morning. There were various arguments about money and her needing to go to a bank. She stated that she refused at the time and that she was not going to give him any money. She stated that the argument continued while they were inside of the residence, to the point that she actually left the house to cool down. And when she came back, he came back out and greeted her, she says, with a firearm, and told her that if she was to leave again, he was going to assault her by punching her in the face.
I think the pertinent part of the warrant would be where the officer states that Mr. Davis and Miss Shanti Ford lived together and were in a relationship.
Yes.
So that's in the warrant, and that's why it's family violence. Mr. Davis, just FYI, Mr. Rhodes, the prior conviction was for simple battery, no DV.
Thank you,
I
Judge.
don't live with her, Your Honor. I live in
And your attorney and you can contest that during the trial.
even when I came to the thing, I was not there when they came to arrest me or whatever, because I don't live there. When they came out to do the police came out or whatever, I was not even there. They didn't arrest me or anything.
Mr. Davis, they are basing the warrant on what the victim reported to the officer. Now, if you have a different set of facts, you need to speak with your attorney, and that he or she can then file the appropriate motion to challenge the charges. But if you're trying to tell me that you don't live there, then my big question in my head is, why would they ask that you go back to the house to get your belongings?
Who said that?
The last bond order and that was where I got the idea that you lived there.
Since that last order, I've moved away. I don't even live
All
there.
right.
I'm not even with her no more.
Domestic violence is for partners who have previously
About
lived
money
together. Okay,
issues,
I'm done. Thank you, Deputy.
I don't even live there no more. So how could I? How is this domestic anymore?
Okay, why don't you take a law class and then we can talk? Deputy, I'm done with Mr. Davis.
And Your Honor, just a brief point of clarification. I was reading the warrant a little too fast. The victim in this case said that she thought she heard gunshots and she's unaware of whether it was gunshots or fireworks. I just wanted to.
He's not charged with a firearm in this matter. The only thing I'm talking about right now is whether he lived at that location or used to live at that location. And by definition, that is family violence.
Yes, Your
If
Honor.
the defendant and the victim used to live together, that still makes it FV.
Even when I was arrested, she actually even told him that I don't live there. We were just dating. I don't live at the residence. I've never lived at the residence. I may have some stuff there that I need to retrieve, like my laptop.
Wait. Didn't you just say you moved out? You moved out of a place you never moved into? No.
Some other things, but I don't live there like solely. Never have.
Okay.
I live in a whole another city. I live in Cumming, Georgia.
All right.
So there's nothing I can do about that.
It's simple battery or simple battery family violence. My point is that I have given you a bond order that is word for word the same as the previous case.
Okay, so my bond is $2,000.
Surety bond.
Surety bond. And there's no way, because I have jobs that are out there right now, Your Honor, that I'm not like a contractor. I put together people's houses. I got things out there right now that I need to, take care of, because if I don't take care of them, it's going to be a legal matter against me.
Be very careful of what you do from this point onwards then.
No. So there's no way I can possibly, Your Honor, get a level 3, level 2.
Not under these allegations, not based on your prior case and not based on your prior conviction.
He's
involving
pregnant.
the same victim in the same location.
So if I come back to court, will I be able to try again, or what's the deal?
I don't know, sir. You have to talk to your attorney. I'm not your attorney.
Okay, thank you.
Mm-hmm. Kevin Brewington
And you
is
never
accused
will be with
of
that
hit and
attitude.
run, failure of the driver to return to the scene of the accident, and aggressive driving from December 31st, 2025. He's also got an additional count of disorderly conduct from the same date, and that's on position 3. Position 2's case number is 26CR40J, and the other one is 26CR041J. Mr. Brewington, you've been advised of your rights, and your attorney is going to be Miss Anthony. Any priors?
Well,
22. Yeah, second arrest, open DUI out of Gwinnett County from last year.
All right.
That's what we need, Bobby. We need that other guy's mommy to come and hi, Bev.
And I'm sorry, did you say 22 arrest cycles?
Second.
Oh, second arrest cycle. Okay, thank you. And do you know the date of the DUI arrest by any chance?
Just see your walls.
No,
Okay.
I have to look it up.
Okay.
I just wrote down the year. That's it.
That's all right. Thank you. Mr. Rhodes?
Yes, Your Honor. This incident occurred on December 31st of this year, Your Honor. Well, I'm sorry, of last year, December 31st, 2025. Johns Creek police officers responded to a traffic incident on Haynesbridge Road, where they were met with the victim, whose name is Miss Paula Mello, and who informed them that a gray 2025 GMC Hummer had been following her closely, honking his horn and presenting obscene gestures with his fingers and a manner to Miss Mello that made her feel threatened. The driver of the Hummer was later identified as the defendant, Mr. Brewington. Officers were able to observe video which shows the Hummer overtaking Miss Mello in her 2023 black Tesla, and essentially her driver's side wheel area, she was overtaken and struck by this particular defendant. And when he got out of his vehicle, he brandished a firearm. Well, he had a firearm in his right hand. He never necessarily pointing it at her, but it was visible, and appeared to be yelling at Miss Mello. Miss Mello did advise that there was a child in the vehicle with her, and so therefore, to hopefully get him to control some of the behavior that he was displaying on this day, which is the basis for adding the disorderly conduct. It was a part of the same incident as well, Your Honor. As such, Your Honor, given his history, you've heard 22 cycles. I believe that I believe you heard 22 cycles.
Second arrest, sir.
Oh,
Second
I'm sorry.
I clarified, it was his second arrest.
Oh, second arrest. I'm sorry. This is his second arrest. As such, Your Honor, given the brazenness of this particular incident and what has happened with the victim here, we're asking for a total of $20,000 good bond, and that he has no further contact with Ms. Paula Mello, that he undergoes a behavioral health evaluation and treatment, that he's to have no weapons or firearms while out on bond, that he's to attend 20 anger management classes at his own expense while out on bond. Your Honor, I do believe that there is an open DUI out of Gwinnett County from September of this year. And the state's recommendation is based on the brandishing of this firearm, the vulgar act towards a female with a child in the car, just unwarranted, Your Honor. Thank you.
Miss Anthony?
Yes, Your Honor. Mr. Burlington he's been in Georgia for about 18 years. He did provide a good Georgia address. He is completed high school and college, as well as his MBA from UGA. He is gainfully employed with years of experience in insurance. He does have a significant other who is here in Georgia, and so we just ask for a signature bond or the lowest bond the court inclined to impose.
Okay, thank you. On the hit and run, that's going to be 2,500. On the aggressive driving, that's going to be 7,500. That's a $10,000 surety bond. On the disorderly conduct, that's going to be a 3,500 signature bond through pretrial services level 3. So for both cases, he's got a split bond of 13,500.
13,000. Now the other domestic violence guys and things like that, $2,000 bond. But this guy had a gun, took a gun to a road rage incident when there was a little kid in the back seat. So I'm not saying 13,000 is too high. I'm not. I'm just saying, what a difference. You don't have no arrests. You know why Victoria doesn't have no arrests? The police are scared of her. They know better. She gives them a look and they just get in their car and they run away.
500. For the signature bond, he will report to pretrial services once a week. He is not to consume any illegal drugs. He's not to consume any alcoholic beverages, and he's not allowed to own or possess any firearms. So if he owns any firearms, they have to be surrendered to the authorities within 48 hours of being released for destruction. He will be subject to random screens by pretrial services. Pretrial monitoring will be for a period of 8 months. Also, he's not allowed to operate any motor vehicle until further order of the court. In the event that he has a valid driver's license, no, I'm not talking.
I would have been fine. Cat, camera, tree, dog. Cat, camera, tree, dog.
Talking about limited driving permit. I'm talking about a valid Class C driver's license, adequate insurance, and proper registration. He may then petition the court through motion to have this restriction lifted. Thank you.
At this time, please.
Y'all trying to hit me up with cash charges I didn't do.
Okay, apparently we're just starting at the beginning again. So if you haven't seen that, lovely man. He's at the very beginning. You're going to have to take the VCR and take out the tape and put it in your little car that rewinds your VCR tapes for you. Ah! There's a cat. Oh, where the hell did that come from? All right, if you're here for court, it's over. We did court. So if you're here for court, you can go now. Bye. Thank you for coming out. I appreciate it. Oh, man, guys. We did it. We got through a Sunday live. Yes, sir. I appreciate you guys coming out. I do. There was a steady 24 of us the whole time. It dipped and went up, but there was a core 24 of us that stayed together this whole time. This one, JK, ready?
I ain't never been around that stupid
And then later on, we had the boy who kept putting holes in his father's wall at the house. I bet those two know each other. And then Miss Kiswell or Stairwell or whatever, she needs to date one or two of them. That would be awesome. Awesome. No, cats are not about to take over again because we got rid of almost all of them. Yep. We just have my cats now. Well, there's one that's still down there, Methany. She can't leave yet because she's not fixed. But she's going to leave very soon. That's how I end my streams every day. I tip my desk over. My desk is really a white fold-up table. But it's sturdy and it's long. It's much longer than desks. So if I want to make it look professional, I have this black tablecloth I put over it. And then it looks fine. But this is my bedroom, so I can have a white fold-up table in my bedroom. I'm the only one who comes in here. So... All right, guys. We have, because she's like a spazoid cat. Literally, she spazzes. Like, if you just go to pet her, she gets so excited. She bounds into you and makes you pet her, and then she gets super pissed off at you for petting her. Super pissed off. So she scratches you, but then she screams, meow, because she wants you to pet her. So you put your hand out, she runs up to the hand to get petted, and then she does it real hard, and then she gets mad at you for petting her. Methany. Call her Meth. YouTube makes me sad all the time with their emoji game. All right, guys. Thanks for coming out. I shall see you all again, I guess, in a couple hours. No, Josh, we ain't doing OJ tonight. Knock it off. OJ's almost finished anyway, so let's pace ourselves. Let's make the end be great and not fast. Okay? Can you do that? All right. Bye, guys. Love you. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh see